The purchase order was for $12,818. We gave them net 62.
I felt really compelled to stitch this creator's video, not necessarily in response to this creator, because what happened to her was absolutely atrocious. And unfortunately, it is very common in these industries. But because I, in addition to being a trademark attorney, I also represent a lot of CPG brands. That is also known as consumer packaged goods. And in that industry, we see a lot of this type of deal where the company that you are actually fulfilling an order on behalf of requires some kind of net payment deal, net payment terms. And effectively what that means is you fulfill the order and then they pay you on the terms that they have set in the contract. So you deliver all of the raw goods, you deliver all the raw materials, you deliver all of the things that they are asking for. And then when they receive it, then they decide that they're ready to pay you after a certain period of time. So during that period, you are bearing the cost of all of it. And it's not just CPG that this happens in. This happens in industries like hers, also with artists who license out artwork, do custom designs, that kind of stuff. So we see it a lot. And the reason I wanted to stitch this is because when negotiating these contracts, there are certain things that you can put in place in the agreement that can help make it easier if these companies decide not to pay, especially because litigation is expensive. I would probably say the first thing they should do is sue. But if that's not feasible or commercially feasible for you, there are things that you can do at the outset of your agreements to make it a little bit easier for you to collect that money on the back end and to make them more likely to pay. So let me go through those with you. Number one, in your agreement, you should always have interest on late payments. So if they make a late payment, they owe interest and that interest continues to accrue. If you are going to give them some sort of net payment terms, then they need to make a payment. Now, this isn't always possible for every type of agreement, but sometimes you can have what's known as a retention of title clause in your agreement. What this essentially means is that the goods don't belong to the other party until the payment is actually made. So while you might have given them those goods, the title does not transfer to them until payment is made. That can be very helpful because then you can actually reclaim those goods. But like I said, it's not always applicable in every situation. So you probably want to talk with your lawyer if you're going to include that. Personally, I like partial payment clauses because I want to make sure that they're as committed to payment as possible. So I want something like maybe 50% upfront or 20% upfront or a deposit upfront, because if you're going to be fronting the cost of goods in order to create and fulfill the order, you want to at least be paid something for that effort in case they decide, hey, you know what? Thanks, but no thanks. We're going to cancel this contract off altogether after you've already, gotten the raw materials in or gotten the order together. And now all of a sudden you're scrambling trying to find another buyer. Now, this provision would be for contracts that are sort of payment plans, right? So if they are paying you on a certain schedule, but you should have what's known as an acceleration clause in those contracts where basically if they miss a payment, then the entire balance becomes due immediately. That's also good to have in your contract. You can also include something like a credit limit and review of credit clause in your agreements. It's kind of like an audit provision. So if you think that the company you're working with might have solvency issues or payment problems, you can actually put in your contracts that you have the right to, review their credit or only extend a certain amount of credit to them in the agreement. And once you hit that limit, you can have the right to kind of audit certain things to ensure that they have the ability to pay. Some companies don't like including those things, but it's sometimes worth exploring. Always make sure that you have an attorney's fees and costs provision in your contract. So in the event somebody breaches, the prevailing party will get their attorney's fees and costs back. That makes it much easier for you to expend money on attorney, knowing that you may get that money back, especially if you are clearly in the right when it comes to the breach of the contract. Now, this isn't always applicable, but I also like to see some kind of ADR provision in my contracts. That's alternative dispute resolution. So that would be mediation or arbitration. A lot of people just automatically slap these provisions into their contracts without actually realizing the cost. So I'm a litigator. I've been to court before. I know that not always is arbitration cheaper than litigation. Sometimes litigation is actually faster and cheaper than going to arbitration, which can be expensive for companies. But I do really like pre-arbitration litigation mediations. And oftentimes those provisions are really worth putting into your contract or at least considering. So in the event there is a dispute, you just automatically go to a neutral third party and have them help you decide the case. Sometimes you can consider things like personal guarantees, but for contracts like this, in this situation, they likely wouldn't agree to it because Francesca's is a big company. They're not going to have like the owner of that company personally guarantee the money. But if you're doing deals with smaller businesses, sometimes that's worth exploring. And then finally, always make sure you at least consider a liquidated damages provision. In the event somebody breaches something, you can sort of put in there how much they would owe you in damages in the event that they breach. These are only typically acceptable when there are certain scenarios at play. So they're not always applicable, but they are always worth considering, especially when you're dealing with extending things to other people, such as credit or materials or product or whatever. So you don't get taken advantage of and you don't lose out on this money. So I hope this is helpful for anybody that might be having contractual issues or cleaning up their contracts. If you have any questions, let me know and follow for more.